Hi, I'm David Harmon.
And I'm Maria Garner.
And we are the Employment Strategists.
Today's episode may sound like a law school exam, but it actually is a real set of facts.
It's about the $5 million HR failure.
So what happened? We have two different cases, two workplace cases. The same exact slur was used towards an employee, the same type of allegation, yet one of the cases ends in a $5 million jury verdict. And what about the other?
Nothing.
Gone. Completely
dismissed.
Summary judgment.
That's right. So, if you're thinking, well, one must have been worse than the other, not exactly.
That's the twist. The difference wasn't the word, the slur, or the allegation of the harm towards the employee. It was the employer's response.
Today's episode is really about that moment when an employer does something that goes wrong.
Okay, let's discuss with our legal framework.
Let's level set for a second. When we're talking about hostile work environment claims, the law is looking at a few key things. Was the conduct severe or pervasive? Was it based on a protected characteristic? But here's the part people miss.
The employer's liability does not necessarily immediately attach upon a bad conduct. It may depend on what actually happened, what did they do to stop it, or what they didn't do, and whether or not it was a supervisor who engaged in the bad conduct.
True. Once an employer knows or should know about harassment, they have a legal obligation to take prompt, effective remedial action.
And David, if they don't?
That's when bad facts turn into legal liability.
So let's discuss the cases that we're talking about. The first case, Sample versus Cemex.
So it's not subtle at all. You have a disabled truck driver who endured years of racial and disability-based harassment. Not a one-off.
Not ambiguous comments, not a one-off comment. It was years.
And importantly, he complained. Remember that. Key fact. He complained.
Complained repeatedly. And that wasn't hidden. The employer knew. And what did they do?
They did basically nothing. Nothing. No meaningful investigation. No discipline. No intervention.
And then comes the part that really seals it. He gets fired after speaking up.
That's when the case goes from bad to explosive.
Exactly. Now, you don't just have harassment, you also have retaliation, which juries hate.
They awarded this truck driver $5 million in damages.
And that's just damages. Let's not forget that the employer incurred legal fees, probably tremendous amounts to get through a jury trial, as well as will be on the hook for the plaintiff's successful claims now and plaintiff's legal fees.
Yes. So it's really a multiplied result in terms of damages. So this case is the legal equivalent of watching someone ignore a small kitchen fire and then pour lighter fluid on it.
Yes. So now let's flip the script.
Okay.
The second case, Boston versus Graphic Packaging. Similar allegation. A co-worker uses the same exact slur.
So same starting point, Maria. Same spark.
But completely different response from the employer. The employer acts immediately. They investigate, and the employee who used the slur gets fired promptly.
And that one decision carries the entire case.
Exactly. The court looks at this and says the employer did what they could have done and what they were supposed to do. They responded quickly. They took it seriously, and they implemented an immediate corrective action.
And the result?
Case dismissed.
Case dismissed. Proper conduct on the part of the employer, case dismissed. Summary judgment, no jury, no damages, done.
Done. It's almost jarring how clean that outcome is compared to the first case.
It's all based on employer action. So let's distill this a little bit because this is the entire episode in one sentence. Liability isn't just about the conduct, it's about the response.
And to put it even more bluntly, bad facts don't sink employers. Bad reactions do.
Let's line it up side by side. In case one, repeated complaints, no action, termination.
Case 2, immediate action, investigation, and then determination of the offender, not the person who's complaining.
Same issue, completely different outcomes.
And it's like two employers were handed the same problem, and one treated it like a fire drill, while the other treated it as a background noise.
So it's two case studies, one of what you should do and one of what you should never do.
So if you're an employer listening to this episode, here's your playbook. Act quickly, not eventually. Not even when it's convenient, immediately.
And don't just check a box. conduct a real investigation, a thorough investigation, a meaningful investigation, one that will stand up in court.
Right. And then whatever corrective action you decide to take after the investigation, that action must mean something. It has to be discouraging enough so that the offending employee doesn't think about engaging in the same wrong action again.
Another thing that I think is important for employers to know is that when you do engage in a meaningful investigation, you are setting an example. You are showing the rank and file, other employees, that you take your policies and the law seriously, and therefore you're going to apply them and you will investigate and look into that, so that every other employee who may find out that this has gone on will know this company stands up for the employee.
Yeah, in fact, when you conduct the investigation, David, what would you recommend for the employers to do? Hire an independent investigator, use their HR, hire a lawyer to investigate? What do you think?
Well, sometimes as a threshold, they can start internally and then look to farm that out to an outside independent investigator, which I think stands up better in court.
Especially when the independent investigator actually does what they're supposed to do and conduct the investigation independently without any prejudices.
That's correct, because a company, there is a possibility that when it's an internal investigation, even though I said that earlier, you at least need to get some basic facts together. The complaint is coming into HR, so there is some investigation. But in serious cases like this, they should be sent out to independent investigators, independent counsel.
Yeah, and I think it's critically important when you have serious allegation like a racial slur or a gender-based slur, or when you have allegations that concern either a key employee or a rainmaker or somebody who's high up in the organization.
Oh, especially in a C-suite situation, absolutely should go to outside counsel. So there's no favoritism that is even suggested.
David, one other benefit of using an attorney, right? Not only that attorneys know the law and can guide the company to a better corrective action, but also the protections that hiring a licensed attorney in the state can offer.
Right. Privilege will apply in most instances, but that's the goal, is to have a protected, confidential, privileged investigation.
And also an attorney who's trained into figuring out or ascertaining the credibility of witnesses, right, and complainants, and then also the alleged harasser.
Oh, you have to find the person with the appropriate expertise. You're not going to have a patent attorney run an investigation of an employment matter.
That's fair. Okay. So what are the takeaways? Let's dive into our strategies for the employers and employees.
Well, I think one of them is certainly to have proper policies, proper procedures that are well communicated across the board to all employees.
And particularly the managers, right? Because your managers is your first line of defense. Very frequently, an employee will go to a manager with a complaint as opposed to an HR person, simply because they may have a relationship with the manager. They feel more comfortable with that person. So the managers have to be trained so well to understand when the complaint has to be escalated and taken seriously.
Well, one of the things we always say is that you can have policies, but you need to train as part of the implementation of those policies.
Right.
Just handing out a handbook is only a part of the way to the goal.
Yeah, policies that you don't know. If you don't know what your policy says, it's worth basically nothing.
Right. It's not worth the paper it's written on.
Okay. Now, with respect to the employees, what are the strategies that we would recommend to the employees?
Well, if an employee feels that there has been a violation of the policy or the law, the employee should step up and file a complaint, bring a complaint to HR to notify that something is wrong.
Absolutely, because from the employee perspective, if the employer does not know that a wrongful conduct is occurring, they cannot do anything to fix it.
You can't investigate something you don't know about.
That's right. And if you are reporting misconduct as an employee, do it in writing if you can.
Right. The other thing that does for the employee is it provides protection from dismissal and thus retaliation.
Yeah, pay close attention to how the company responds, because that response is going to define your case.
If you want to learn more about what to do in these circumstances, check out our YouTube video.
Link is in the caption.